Hello, my name is Nwa'ndo with Smithers and Ume-Nwagbo LLC, and today I'm bringing notes from my legal pad, the Employment Law Edition. Today we are going to talk about the common mistakes, or some of the common mistakes that employers make, and why they need to talk to an employment lawyer before they start making any of these decisions. First common mistake: signing someone up as an independent contractor and treating them as an employee. When you have an individual that you want to hire and you know that you don't have the money to do all that is necessary for an employee, you may think that the better option is to sign up that person as an independent contractor, but from all intents and purposes, you are using them as an employee. So you signed a contract that is called an independent contractor agreement. You've gotten that right. But have you actually looked at what they're doing for your company? Have you looked at who's providing the tools of the trade? Have you looked at who has a right to control what they're doing? And more importantly, have you looked at whether or not the person can actually go out there and do the same work that they're doing for you for other companies? If they can do that, and you prevent them from doing that, then you have basically created an employer-employee relationship, and that means that you need to pay them as an employee versus an independent contractor, which means that after working 40 hours, they're entitled to overtime. They also are entitled to have their taxes paid by you, not them. Another common mistake that a lot of people make is to fire people before they've done their due diligence. What do I mean by that? A lot of companies make sure that they provide every employee with a handbook, an employee handbook, policies and procedures, call it whatever, but at the end of the day, they provide a handbook to every single person working for them, and it lists conduct that is acceptable and it lists conduct that is not acceptable. And when you violate one of those conducts, then they fire you immediately because they are the employer and they feel they have the right to fire them. Well, before you fire the next person, pump the brakes, because we need to look and make sure that you've done everything that you need to do under your policy, not just federal law, but also under your policy. Because let's take, for instance, you've hired person A to come and work for you, and they show up late twice in the same week. Are you entitled to fire them? I don't know. Maybe you do. Let's look at your policy. If you have a policy that states that the first time somebody shows up late, I give them a verbal warning. If they show up to work late, you give them a written notice. And then if they show up late the third time, that's when you fire them. You can't fire them until they've come to work late 3 times in a row. So because the employee can't actually go ahead and file for unemployment, once you fire them, we want to go ahead and pump the brakes before you've made any decisions about firing anybody. Let's stop, have a conversation with the lawyer, see whether or not what the employee did is to the level of firing them. Let's actually look at your policy. First of all, let's make sure you have policies in place. Let's make sure they actually are stating what the law states and provides that you can do. And let's make sure that every employee has those policies in their hand and that they are following them just like you are following your policies, so that when you fire people, you've actually done your due diligence to make sure that you can fire the person when you've made that decision to fire them. So to get more information about the attorneys of Smithers and Ume-Nwagbo LLC, please go to our LinkedIn page, our Facebook page, and definitely our website at stulawgroup.com.